Welcome to another episode of the Criminal Law Department Presents podcast, a production of the Criminal Law Department at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia. Every 2 weeks, we release a new episode. Today, we're going to have a conversation about a recent opinion from the Court of Appeals for the Armed Forces. Please note that these episodes may contain facts and circumstances surrounding criminal trials. Listener discretion is advised.
All rise! Hear ye, hear ye, hear ye. The Honorable United States Court of Appeals of the Armed Forces is now open and in session. God save the United States of America and this honorable.
Welcome to a special episode of our Criminal Law Presents podcast. Today, we have the distinct honor of talking with Colonel Retired James Pohl, a distinguished leader in our military community. As our guest for this year's Hodson lecture, Colonel Pohl brings with him a wealth of experience and insight. Colonel Pohl was kind enough to agree to sit down to talk with Major Dustin Morgan and myself about our different perspectives as former trial judges.
And you'll hear that interview next. I had the opportunity to sit down and ask both Colonel Barna and Colonel Pohl those questions. And what we're hoping to bring to you as listeners is a unique perspective from someone, Colonel Barna, who just left the bench as a military judge, and Colonel Pohl, who sat as a military judge for well over a decade. And they bring unique practice points for those out there practicing military justice. So you'll hear that over the course of the next 20 minutes, and we'll send that over to there now. Hello, and welcome back to another episode of Crim Law Presents. Instead of our normal CAAF Chats episode, we have a special episode today. I have the distinct pleasure of speaking to the 51st Hodson lecturer, Colonel Retired James Pohl. Joining us today is also another special guest, our department chair, Colonel Trevor Barna. Sir, good afternoon.
Good afternoon. How are you?
I'm doing well, sir. I hear Colonel Pohl has an interesting career, and he's going to tell us about it over the course of the next few minutes.
Yep. So we just introduced him, and he gave an outstanding lecture to our military judges course, as well as our graduate course students. Judge Pohl started his career in 1980 and served for 38 years, including 18 years on the trial judiciary, involved in some significant cases throughout his time, including one of the Abu Ghraib cases, as well as on the Shiri when he was down at the commissions. On a personal note, I did appear in front of Judge Pohl 17 years ago, and so it's a nice march back into time to see him on the dais, lording his knowledge over me. Again, I really appreciated seeing you, and thank you for coming down, sir.
It's my pleasure to be here.
Okay, gentlemen, since both of you have the unique perspective of being former sitting judges, I have a few questions I'd like to go over with you and answer them for practitioners. So first, what's the most frustrating thing that an advocate can do in front of the military judge?
So I think this is a personal opinion. It's not really a across the board. All judges have and we don't like to use, I personally don't like to use the term pet peeve, because I think that sort of implies that it happens the same way every time. I would say the biggest is when counsel shoots from the hip. They say things they don't know, and they're embarrassed or afraid to say they don't know. And so then they go down this rabbit hole, and you could tell they're saying things they really don't believe and or don't have any support for. And the problem from the judge perspective, at least my perspective, was then I have to tease that out, figure out why they're saying it. Do they really understand it? And do they even know they're saying something wrong? And it usually ends up being the case where they are trying not to look like they don't know, and they just don't. That would be my biggest problem. And I think it also, for defense, when defense does it, it really puts them on the back foot, and they're having to try and correct that, both for their client and I think for the fact finder as well.
For me, it just on a tactical level, it's punctuality. I set a time for the case, a time for recess, and I expect counsel to be ready. Usually you can train them when they are ready, and so it gets to it, but nothing aggravates me more than sitting on the bench waiting for counsel to show up. But on a bigger issue, it's a lack of sense of urgency I see. I've been retired for 6 years, so perhaps it's gotten better, but there seems to be an unwillingness to try the case. Defense asks for a delay. Trial counsel does not oppose the delay, and it gets kicked down the road, kicked down the road, kicked down the road. And the case doesn't get any better, doesn't change, but just it seems way too often. And I think it's partly just maybe from a fear of actually trying the case, but just the lack of sense of urgency. Maybe because the caseloads are not that high these days that you can do it, as we were discussing earlier before this started. And then you have the unopposed delay that's not relayed to the boss that we didn't oppose the delay. And then the boss tells the convening authority, the judge now is delaying these cases. So that would be on just a processing case type of thing, is getting the case set for arraignment, trying the case in a timely manner, understanding there's work to be done, but let's just get the case going. And sometimes it seems like the only one who wants the case to move is the judge.
What I would say also, in response to shooting from the hip or not knowing, is taking the time, or just having a little bit of understanding, asking the judge, can I have time? I don't have the answer for this, or I don't know. I'll get back to you, or can I have 15 minutes? I can't say that I ever told the counsel, no, I won't give you the time to figure this out. I wouldn't necessarily give them all the time they asked for, but if a counsel says, I need 30 minutes to figure this out for you, or I need 20 minutes, I can't think of a time I ever said no. And I would much rather have them ask for some time than to have them put something on the record that they really shouldn't be.
So we got the worst part out of the way. Talked about trial counsel can do and defense counsel can do wrong. So let's talk about the opposite end of the spectrum. So for our practicing counsel out there, what's the best thing they can do before they step into the well to get ready for a court-martial?
Be organized. And I can tell you this: I can look at counsel's desk, particularly on a multi-day trial. If it's neat and organized, they have a plan. They keep their list of exhibits, what have been admitted, what haven't been admitted, what need to be offered. They have the manual for court-martial there. And this may seem like basic stuff, but there are times I'm wondering what they're doing. And on the side thing, if they have their iPhone, in my day, the BlackBerry, that should not be on the desk. But to me, it's an organized desk, an organized presentation is an effective presentation. It's kind of piggybacking on what Trevor just said. If you haven't thought all these things through, and there are things that come up you don't, then you have not prepared your case properly. So the best counsel are the organized counsel who's, by the time they get to the courtroom, they have a plan of how to approach the whole case. A little easier for the trial counsel because they know exactly how to lay it out. Defense, a little more difficult, but again, part of being a defense counsel, anticipate the government's case and respond to it, and not say, I need another 40-minute delay, judge, to prepare my cross-examination.
I would say in line with that as well is the idea that counsel need to really have the conversation with one another. And I don't mean defense and government. I mean the government counsel with one another, the defense counsel with one another, because it does feel from time to time that you've got four counsel and they're all trying different cases. So just an example, you'd have a trial counsel who's conducting a direct examination and the assistant trial counsel is clearly not paying attention, off doing something else, not following along, not paying attention. And then when they're asking somebody else another question, it seems as though they haven't been paying attention to the trial. So it feels like there's this lack of coordination internally to the trial teams. You can see it in defense where someone is listening to the cross, they're conducting the cross, and their assistant defense counsel is not paying attention. Same thing with paralegals. Paralegals either not in the room or not understanding what's going on so that they know what's happening in the case. It does feel, to me, it seems if they're going to prepare the case, they should do it as a team. They should be working together. It shouldn't just be I'll take this witness and you take that witness. They should all be working in lockstep so that they can help each other rather than I did my part and then I'm moving on.
So next I want to focus on just kind of shaping your battlefield for the actual trial. We talk a lot in this on this podcast about filing motions, shaping your case. So based off that, what do you think is either right or wrong with the motions practice in courts-martial today and as you've seen it?
Copy and paste, frankly, is the easiest answer I can give you and the fastest. Is there's a lot of great work product that's out there from very, very smart people. The danger is, I know that because I see motions that have been around for a long time from the same people over and over. It doesn't mean that you have to rewrite a motion from beginning, doesn't mean you have to recreate the wheel, but it shouldn't just be changing the title of the case, changing your name and then signing it. You really have to be deliberate. It has to be the law. I've seen those cases where the law doesn't seem to have changed, even though we know there were changes. The facts are not exactly in line. So I would say that's a danger to the motions practice, is the cut and paste, getting the opportunity to make sure it's the right motion for the right case. And frankly, you're asking for the right thing. Counsel have to know what they're asking for, and the judge has the authority to grant it.
Yeah, I certainly agree with that last point, that they have to ask for something that the judge can give them. And it's funny, sometimes they don't ask. They say, this is all unfair. And you say, well, what do you want? Well, it's unfair, Judge. That's not it. My biggest pet peeve, though, when I was on active duty, I'd get a motion from one side, usually the defense, with its version of the facts. I get the government reply with its version of the facts. We'd call witnesses and get a third version of the facts. And it was like 3 separate cases. I understand that government and defense won't necessarily agree on all the facts. Defense has access to the accused version of it, which I suspect sometimes they buy hook, line, and sinker rather than investigating it. But the facts should not drift too far apart from everybody's version. And I would tell counsel, focus on developing the proper factual predicate. The judge is going to know the law, should know the law, but don't emphasize so much on the law. If you give the correct factual predicate to the judge, cite the correct law, you have the best chance of persuading the judge of your position. But if your facts are messed up, you immediately lose credibility with the judge. When witnesses come on and contradict what you said are facts, it doesn't look good for your motion. But that's, I don't know whether, Trevor, you had that experience, but the factual predicate of the motions were always a struggle from getting them consistent there.
And on that same note, I would say that I did appreciate it when counsel could agree to some of the facts, and they would just say it. We agree with 1, 2, 3, 4, and 5 of the opposing counsel's motion. We don't have any issues with those statement of facts. And then we can really litigate what's at issue rather than me having to stop and say, okay, does everybody agree to number 1? Yes, we all agree. Okay, how about number 2? Yes, we all agree. And it's not that I don't have a problem doing that or didn't have a problem doing that, but I think it would have clarified for the counsel when they're making their arguments what's important, rather than fighting over stuff that they already agreed to.
So shifting from advice to the counsel maybe listening and getting more into both of your time on the bench as a military judge. So what do you wish you had known, or what do you wish you had done before you sat your first case as a military judge?
Well, let me address what I wish I had known. I think because of my previous criminal law experience, and I've been practicing attorney for about 24 years before I hit the bench, I thought that I knew what I needed to know to go be a judge, and it turned out that was really not right. I needed to know a lot more. I needed to understand a lot more. I really thought I had an understanding of sentencing and how I would take on sentencing on cases, and it was much more complicated, much more difficult than I realized. And I just thought, well, you've had a lot of cases, this should be a no-brainer. And it was much, much more difficult than I thought. So I think probably we're all very confident. We all are type A personalities. I think probably a little more humility and really just kind of understanding when people tell you it's going to be hard, they're trying to help you. And I thought I heard it, I understood it, but really it was far more difficult than I thought.
Kind of rephrasing the question, because I didn't want to answer that one. The biggest jolt to me as a judge was walking into the courtroom first time and sitting behind the bench in a judge alone guilty plea in a child molesting case. A completely different perspective. I tried a lot of cases on both sides, trial counsel, defense counsel, and I said, the judge is easy, just sitting up there. But kind of as Trevor said, all of a sudden it's you there. And it just struck me as, okay, now I got to be both the adult in the room, be fair to everybody, and try to get this right. And you're never sure whether you're going to get this right. So to me, and could you know that ahead of time? No, you know it when you try your first case.
So this one hopefully is a little bit easier. So what was your favorite part about being a judge?
So I had 2 things I would say. First is having that camaraderie with the judges. learning from those judges, including, thinking back to how Judge Pohl acted when he was on the bench, how I was going to adopt some of the things that I could that would work for me, having those conversations, really in-depth legal conversations with other judges about the law and about process. I learned more from those judges and being a judge in 3 years than probably I'd ever really known before. And I would say the second part is working with and having conversations with counsel in the bridging. And I know that's a sensitive topic for some judges and counsel alike. Should you talk to a judge? Do you listen to the judge when you're doing bridging? It's just one person's perspective. It's their opinion. Should you change anything or do anything because they're offering you an opinion? But I think when you start talking to counsel about preparing your case and presenting and just the performance aspect, because we're not getting into the deliberative process, but just here's how we can become better advocates. Here's how you, government, can become a better advocate. Defense the same. I try to stay away in most cases, if not all cases, from this was effective or not effective, but in terms of you can do better, we can always do better. And I did ask on occasion, why did you do this? What was your reason for doing that? And then again, I tried not to offer a good or bad or right or wrong, simply, what was your thought in doing it this way? And sometimes I think it was eye-opening for counsel because they didn't know. They hadn't really thought about it. They just assumed this evidence was coming in. Or they just assumed something was going to happen. I couldn't give them the rulings or the basis for the rulings, but I could offer them as far as their practice and how they're thinking about their cases. When you're building a case, you have to think about all of this. It can't just be, I'm going to assume all this evidence is coming in, or not knowing how that particular fact is going to come in.
For me, it kind of similar. What Trevor said is seeing the growth of counsel, who through hard work and trying become much more professional and better lawyers and better advocates, which quite frankly, from a judge perspective, that's what you want. Quick war story. I tried a case in Hanau, Germany. When the case was over with, I went to the OIC of the Hanau field office. Case was over, given this, I forget what the case was about, and I told him, then Major Mendelson, that your counsel is really improving. He's really done a good job. And he said, that's good to hear because he's hardworking. And I said, it shows. And those are the moments that I go, I'm glad I'm a judge, because maybe something I did got him to do it. Is probably his own efforts. But that's, to me, was the most encouraging thing. You didn't see it in every counsel, but when you saw it, those little gems really made it a pleasure to go to work. And when you had them in front of you, you knew they were going to be prepared. They were going to be organized. And that made my job easier, but it also made me proud to be a member of a corps that we have this level of professionalism representing either the accused or the government.
I would say also that's something unique. Having practiced in the civilian world, you may have a judge who will offer you, and civilian judge, who may offer you some aspect, the best thing you did was this, but it wasn't really with the same interest and effort in improving the practice of attorneys. And that's not their purpose, and it's a completely different system. But the fact that we have that, and that we want counsel to improve, that I want counsel who are appearing before me to, in the future, be a judge and do the same things, I think really is the right approach to improving the practice of law, and particularly in military justice.
So you indicated this a little bit in your speech to us earlier, so maybe we got a preview of the answer. But for the listeners, what was the hardest part for each of you in being a military judge?
Actually, that's an easy question. Sentencing. In my day, it was a unitary sentence. We had no parameters, no guidelines. I had an accused who was a volunteer. My son went through basic training at Fort Benning, later through OCS, so I'd go to his graduation, and I'd see how proud the parents were of their son, or in this case, all sons, because male only, were when they graduated and became a soldier. And sometimes the next time the parent would see that child is in court, where his career is over with and he's being convicted. And that's hard. And it's the parents did nothing wrong. The kid did something wrong, obviously. But to me, on those kids, now, to be fair, not all sentencing cases were hard. Child molesters were not difficult for me to sentence. But I'm saying is I'm talking about maybe the lower level ones. But even then, every one of these soldiers, you knew what you did would change that life forever. And anecdotally, I'd go back and tell my son, there are people making bad decisions a little older than you that will affect the rest of your life. So kind of think about it. But that to me was clearly the hardest part of the job.
So I agree. Sentencing is hard, and you mentioned it earlier, sir, during the lecture, and I just wanted to reiterate for the listeners. You talked about it's not. I think sometimes the council think that the reason it's hard for judges to sentence is that we're sensitive to, and we're too soft on the accused, and it's not that. It's that there are so many things you have to consider when you're determining the right sentence. What is the right sentence for the offense? What's the right sentence for the accused? What's the right sentence based on the impact on the victim? What's the right sentence on the impact on the command? And when you start putting all of those factors in, you start looking at the rules for court-martial that tell you what you're supposed to consider, what you're not supposed to consider, it becomes an interesting, both intellectual and, quite frankly, factual decision as to what's the right sentence based on the offense, the facts, the accused, the victim. All of those factors come into play into a very complicated decision matrix for a judge. And the question that you were asked, sir, earlier was, well, what do you do? How do you figure this out? Is it a hunch? And I had a visceral reaction to the question, is it a hunch? I don't know any judges who, maybe you can correct me, who have said, I did this on a hunch. It's very reasoned. It's very specific. It is very lengthy. And I would say on average, even though I would spend a lot of time on the findings deliberation and determining whether or not the facts were there and the evidence was there and the elements had been proven, getting into what's the right sentence for a case is complicated. And I think I point to practitioners. I do think counsel are looking at it the wrong way when they're trying to divine what we're going to do in future cases. Because I know what was happening is I would give a sentence and, we didn't do unitary, we did segmented sentencing. And then I could see the wheels turning. They're trying to figure out, well, if he gave this in this case, in this future case, he's going to give the same thing and he's going to do this. And I tried to disabuse that and say, I'm not giving you a formula. It doesn't exist. That's what I'm trying to explain. I look at every case independently. I look at all the facts independently, everything. And that's why it takes so long. It's not just I did this before and I'm doing this again. I try and be intellectually consistent as much as I can, but it is not this is what I did, therefore it's going to be this way in the future.
Yeah, just like that, a couple of points. One, I agree. I didn't mean to emphasize just the accused. There's a myriad of factors that go into your...
Well, I stole that from you, so I had to from this
just from Trevor. The other thing about the predictability of sentences, I tried a case in Iraq, back-to-back guilty pleas, same offense, different offenders. I gave one guy one sentence and the next guy a higher sentence, virtually in the same day. So the bridge of the gap of guy number two, he goes, Judge, why did you give a different sentence? I go, individual sentence for individual cases. And it really is. I mean, I could, in my mind, I knew I could articulate why this guy was treated this way and this guy was treated that way. I don't feel as a judge it's appropriate to tell that to counsel because you're getting too close to the deliberative process. But if you want an individual sentence, don't then look for the judge to follow the same formula on similar offenses. Because quite frankly, in my experience, Trevor, maybe I did, is that there are rarely identical offenses. There's something different about the accused, about the offense, about culpability, about the victim, about the command that make each case kind of its own unique paradigm. And based on experience in trying cases, you have an idea of what you're going to go, and then you do the best you can and hope you got it right.
Okay, Colonel Pohl, so these last two are for you. So looking back, what's been the highlight of your career as a military judge?
What I feel most grateful for, and again, I'm rephrasing your question, as I was allowed to be a judge for 18 years. And in those 18 years, I knew I grew as a judge, but I also grew to kind of understand, like Trevor said earlier, that there were things I didn't know, that there's a certain amount of, and I spoke to this earlier, humility that you have to have as a judge, that we don't know the accused that well. We don't know what we don't know. And so by staying in that position for 18 years, I believed I achieved a level of competency where I was comfortable going to court every day, where I kind of thought I knew what I was doing. And later on in my career, I did the military commissions, a completely different system, and I'd go to court there and not feel I knew what I was doing because the rules were so odd. But the highlight of my career was staying as a judge for 18 years, trying court martials.
So we look back a little bit, sir. So looking forward, what's next for you?
After 38 years, I retired. My wife was a school teacher. She retired about the same time, too. She followed me from post to post to post. She had to re-interview for jobs. I never had to re-interview a job. I just got new orders, go someplace else. She had to get new schools, new friends, new social circles. When I retired, I said, it's time for me to take care of her. Whatever she wanted to do, it's her time. And so that's what's next for me.
Well, I know myself as a practitioner still, this was super fascinating and hopefully super helpful for each of you out there listening. Thank you both, gentlemen. Your insights are definitely invaluable. And that will do it for this episode of Criminal Law Presents. As always, please like and subscribe our podcast, and we'll see you next time. Thank you.
Thanks for joining us today for another episode of the Criminal Law Department Presents podcast. If anything you heard sparked a thought, we'd love to connect with you. Your comments help us create better future content for the field or the fleet. Reach out to us on Facebook or Instagram. The information can be found in the show notes for today's episode. The views expressed in today's podcast are those of the presenters and not necessarily the Judge Advocate General's or the Department of the Army or the Department of Defense.
Board thanks counsel for both sides, and the court will stand in recess until further order of the court.